Hello. I want to give you a preview of what's ahead in 2026 for financial services and credit regulation so that you can assess the commercial, legal, regulatory, and compliance impact on your business. The focus for the year will continue to be managing operational risk, at the same time as regulatory changes. Conduct risk is the risk of inappropriate, unethical, or unlawful behavior on the part of an organization's management or employees. Such conduct can be caused by deliberate actions or may be inadvertent and caused by inadequacies in an organization's practices, frameworks, or education programs. Outsourcing increases third-party liability risks and cybersecurity threats. Systemic misconduct refers to repeated breaches in an organization of the same type, rather than isolated incidents or multiple breaches of different kinds in the same organization. Failure to manage these risks will result in remediation costs as well as a fine and reputational damage. Financial services are regulated in Australia by a number of government agencies, mainly the Australian Treasury, Australian Taxation Office, Australian Securities and Investments Commission, Department of Home Affairs, Australian Prudential Regulation Authority, Australian Transaction Reports and Analysis Centre, Reserve Bank of Australia, Australian Financial Security Authority, the Australian Competition and Consumer Commission, the Privacy Commissioner, the Australian Financial Complaints Authority, the Australian Communications and Media Authority, the Australian Sanctions Office, the Financial Services and Credit Panel, the Takeovers Panel, as some have the power to enforce laws by court action, fines and penalties. It is important to have procedures to deal with them and keep required compliance records. The regulators consider the following areas. 1. Your overall risk controls and risk management. 2. Failure to meet pricing and fee promises. 3. Customer service failures including responding to customer hardship. 4. Scam and fraud prevention. 5. Information management including IT systems. 6. Anti-money laundering procedures. 7. Complaints handling and dispute resolution processes. 8. Privacy protection, data breaches and cybersecurity. 9. Breach reporting. Let's look at some specific issues. The AML-CTF Act has been amended to reflect board and executive accountability for maintaining a culture of AML-CTF compliance and risk management. In 2025, AUSTRAC issued new rules for existing registered businesses which will apply from 31st March 2026. From 1st July 2026, the Anti-Money Laundering Act will extend to lawyers, accountants, trust and company service providers, real estate agents, and dealers in precious metals and stones. Poor private credit practices, financial reporting misconduct, insurance complaints, and claims handling and misleading pricing are included in ASIC's 2026 enforcement priorities. Continuing enforcement priorities are strengthening the investigation and prosecution of insider trading conduct, predatory credit practices, continuing its work to hold those responsible to account for the collapse of the Shield and First Guardian master funds, unlawful practices seeking to evade small business creditors, holding super trustees to account for member services failures, and auditor misconduct. ASIC's enduring priorities include misconduct damaging market integrity, including insider trading, continuous disclosure breaches and market manipulation, misconduct impacting First Nations people, misconduct involving a high risk of significant consumer harm, particularly conduct affecting financially vulnerable customers, systemic compliance failures by large financial institutions resulting in widespread consumer harm, new or emerging conduct risks within the financial system, and failures in governance and directors' duties. The Australian Prudential Regulation Authority's priorities for the banking, insurance, and superannuation industries are strengthening crisis preparedness, Strengthening all regulated entities' resilience to operational risks. Focus on potential risks from geopolitical tensions, cyber attacks, interconnections, an aging population and climate change. And formalising a third tier into its proportionality framework for banks. The Office of the Australian Information Commissioner's privacy regulatory priorities for 2026 include the use of advertising technology, including pixel tracking, and the application of AI technology in ways that could erode information access and privacy rights. The Privacy Commissioner has published a case study of what can go wrong when using publicly available Gen AI tools like ChatGPT in the workplace. The Commissioner says they will protect and uphold privacy and information access rights when dealing with new and emerging technologies with high impact, including facial recognition technology and forms of biometric scanning, new surveillance technologies such as location data tracking in apps, cars, and other devices, and the preservation of both privacy and information access rights in government use of artificial intelligence and automated decision-making. Separately, the Cybersecurity Act has introduced a mandatory reporting obligation for entities that are affected by a cyber incident, receive a ransomware demand, and elect to make a payment or give benefits in connection with that cybersecurity incident. Privacy Act provisions related to automated decision-making will commence in December 2026. Currently, bills awaiting passage include the Corporations Amendment, Digital Assets Framework, Bill 2025, and the Treasury Laws Amendment, Genetic Testing Protections in Life Insurance and Other Measures, Bill 2025, which includes foreign financial service provider exemptions from the need to hold an Australian financial services licence, as well as the repeal of Stage 2 of the registration process for financial advisors, which would have required individual financial advisors to register themselves with the Australian Securities and Investments Commission annually from the 1st of July 2026. Bills announced but yet to be introduced include bankruptcy law reform, amendments to the Personal Property Securities Act 2009, and the ban on debit card surcharges. The government and the regulators will continue to emphasise the importance of cybersecurity, artificial intelligence policies, and the protection of customers' personal information as financial services undergo a digital transformation. The government will also look to reform the payment system to make it more efficient. There is a transition plan to cease the use of cheques. In the area of consumer protection, there will be an emphasis on the need for increased training to reduce staff negligence and error. ASIC and the ACCC will continue to be active in policing misleading conduct in financial services and the treatment of vulnerable persons. Failing to reflect marketing promises in product terms, fees and interest charges remains a major operational risk. Here is a summary of changes planned for 2026 and 2027. If you would like more information about our online courses, go to learn.brightlaw.com.au.